Hello, everyone, and welcome to Uncivil Law. And today, for all of you who enjoyed our recent district court decision in the case of Steve Jackson Games versus United States Secret Service, we are here with a follow up, also by request of someone on this channel. Thank you for the support. So, today's case is a follow on to the one we covered recently because this is the Court of Appeals decision in the case of Steve Jackson Game versus United States Secret Service. So in this case, the United States Secret Service went into Steve Jackson Games and took a bunch of computer files and emails and other stuff, and they did so under on non-legitimate grounds. And Steve Jackson Games got some monetary damages as a result of this. And the Court of Appeals is trying to decide a fairly technical issue because the court below said there were two issues for them to resolve: whether or not data that was stored was taken, and also whether or not intercepts occurred of data. And both are treated differently under the statutes, as we're going to see. Both produced potential liability. The district court said yes, they did take information that was stored, but no, they didn't intercept data. So we're going to read this decision and see what it has to say as to that technical distinction. Let's get started with this. The narrow issue before us is whether the seizure of a computer used to operate an electronic bulletin board system and containing private electronic email, and again, we're using the term email fairly loosely here because we're talking about some old school email, but yes, and containing this private electronic email which had been sent to, stored on the bulletin board, but not read, received by the intended recipients, constitutes an unlawful intercept under the Federal Wiretap Act as amended by Title I. We hold it is not, and therefore we affirm. So we have two issues we're trying to deal with. We took a whole bunch of data from Steve Jackson Games. We took computers, we took 300 floppy disks, we took other stuff, we took email that was stored on these old school bulletin board style systems, and we took all that information. And so we have two potential issues. We've taken stored records and also potentially intercepted. And these emails, some of these emails at least, some of these emails in particular, have been sent, but they had not been yet read. So the question is whether or not we are intercepting those emails. Now, you have to remember this is old school BBS, so probably it never passed a wire of any kind. This might be something in one user on the bulletin board sent to another user on the same bulletin board, so it may not have transited a network at all. So there may not have been that aspect of interception, but maybe because we interfered before it could be received, maybe that's an interception. But we're going to get into that detail. Let's read on. The district court held that the Secret Service violated the Privacy Protection Act and awarded actual damages of $51,040 to Steve Jackson Games, and that it violated Title II of the Act by seizing stored electronic communications without complying with statutory provisions, and awarded statutory damages of $1,000 to each of the people. And it awarded appellants $195,000 in attorney's fees and $57,000 worth of costs. So we're getting those costs back. But it held that the Secret Service did not intercept the email in violation of the law because its acquisition of the contents of the electronic communication was not contemporaneous with the transmission of those communications. So the district court said, well, when they seized these emails, it was not as they were being sent. So they were not coming through the wire and we had a wiretap, because at least old school wiretaps, not modern ones, but old school wiretaps, you literally would put a physical lead on a wire and you would intercept anything that comes down. So you would basically copy the electrical signal that comes down the wire and you'd record it into some device one way or another. So that's like an old school wiretap. We are literally putting a clamp on a wire, literally reading the stuff that's going down the wire and literally recording that as it's coming down. So here it's like, well, we didn't do that or even the equivalent of that because we weren't trying to capture the email as it was transversing a network. We were simply looking at a record that was stored, and that's different. It's not wiretapping, whatever else it might be. Okay. As stated above, the sole issue is very narrow: whether the seizure of the computer on which stored private email has been sent but not yet received constitutes an intercept as provided by the law. The Act very helpfully provides a definition of intercept, so we are going to use the statutory definition for as much value as it has. So the Act defines intercepts as the oral or other acquisition of the contents of any wire, electronic, or oral communication through the use of any electronic, mechanical, or any device. So, yes, we are looking for oral or other acquisition of any electronic or oral communication, yes. So that's what we're looking for. The district court, relying on our court's interpretation of intercept, held that Secret Service did not intercept the communications because its acquisition of those contents was not contemporaneous with the transmission. Again, that makes total sense when you think again about old school wiretaps and how they're done. Old school wiretaps, you literally tapped a wire, you put a lead on it, and you read things as they're going down. And so you're not reading data that's stored, you're reading data as it's passing through the wire. And there's a difference there between storage. So we didn't take the information from any kind of wire or any sort of equivalent of it. What we did is we read stuff that's stored. So it makes sense that it doesn't apply. Prior to the 1986 amendment, the Wiretap Act did not define interception differently as an oral acquisition of contents of wire or communication through the use of a device. So before, it had to be oral, which is to say it had to be audible. So before, when we did wiretapping, it had to be an audible acquisition, which doesn't really make sense in the context of digital data, but that's what it used to say. So now the law, relative to this 1986 amendment, so in 1986, the act was amended to include oral, or other acquisition of electronic or other communications. The significance of the word or other in the definition of intercepts becomes clear when the definition of oral and electronic communications are examined. Electronic communications, which include non-voice portions of wire communications, cannot be acquired orally. Well, that's partially true and partially not. At least in the old school, in the long, long ago, when we actually had modems, I suppose you could acquire the data orally because the data was being sent through oral means through a modem. That's what you did, right? You converted the digital data into an audible signal that could be transmitted across a wire. And if you picked it up and listened to it, it would sound like static, but it's actually data. And so you could record that and you could demodulate it. You could convert it back into what its old form was. So not sure that's 100% true, but at least with respect to this particular data, we don't have to worry about that distinction because we didn't obtain a modem signal from a wire. We obtained stored data. So the data was not being stored on the hard drive in an audible form. Even if it's audible data, even if it represents audible data, it's ones and zeros, right? It's not audible in terms of how it's being stored. There's not a lot of computers that are using actual audible data for recording these days. Maybe someone's have experimented with it using tapes or something, but not at the moment at least. So yeah, this is not audible data. So that's why we amended the law. Critical to the issue before us is the fact that, unlike the definition of wire communication, the definition of electronic communication does not include electronic storage of such communications. So there's a technical difference in how the things are defined. The email in issue was in electronic storage. Congress's use of the words transfer in the definition of electronic communication adds omission that the definition of the phrase any electronic storage of such communication reflects that Congress did not intend for intercept to apply to electronic communications when those communications are in electronic storage. First, the substantive and procedural requirements for authorization to intercept electronic communications are quite different from those accessing stored electronic communications. For example, a government entity may gain access to contents of electronic communications that have been stored in electronic storage for less than 180 days by obtaining a warrant. Yeah, and that's still the law today, unfortunately. Not that I agree with it, but the Stored Communications Act provides that the stored communications, you have to get a warrant if it's been stored for 180 days or less, but not more. Over 180 days, it's considered to be abandoned. Now, when this act was written, that made a lot more sense because information was not stored on a central server in old school email like that. Most email systems, they would deliver it to you and then they wouldn't have it on the server anymore. So the idea of like it being abandoned if you didn't receive it for 180 days kind of made more sense. These days, however, it makes a lot less sense for people using web-based and cloud-based email where no one ever deletes anything. And so, yeah, now the law treats things that are less than 180 days as though they're yours, and more than 180 days, they're abandoned. So the government can still to this day get electronic records that are more than 6 months old because they are abandoned without a warrant. So that's pretty annoying. So yes, at the time and today, if it's under 180 days, you have to get a warrant. In the old days, that kind of meant a lot more because there was unlikely to be records more than 180 days old. So it didn't really matter, but now it does. So that's where we are. Access to stored electronic communications may be obtained pursuant to a search warrant, but access to a stored wired communication requires a court order pursuant to this other section we just discussed. Because 2701 covers both stored wire and electronic communications, it was necessary in the subsection to refer to different provisions. For the foregoing reasons, the judgment is affirmed. So that is the end of the case from the Court of Appeals from Steve Jackson Games from the United States Secret Service. For those of you who didn't get enough the first time, we are here with round two. And so the issue was very, very minor. It's a very technical issue. When they took the emails, did they intercept the emails? And the answer is no. The emails were stored communications. They met every definition of a stored communication. And pretty much by definition, you can't be intercepting a stored communication because that doesn't really make any sense. Something's in transit or it's stored. It can't really be both at the same time. That would be pretty weird. So yes, the very fact that they are stored probably means definitionally they're not in transit. And if they were in transit, that probably means definitionally they're not stored. It can only kind of be one of those things. So yes, the Secret Service violated the law by taking stored communications because they were under 180 days old and they didn't have a warrant and they didn't follow the requirements. But they didn't violate the Wiretapping Act because there was no wire, real or metaphorical, for them to intercept a communication from. So yes, their liability is exactly as it should be by the law, and that is the end of the coverage of this case.